Good morning. May it please the court. My name is Pamela Williams Kelly, attorney for appellant Shelby County, Tennessee. Also appearing today for appellant is my co-counsel, attorney Catherine L. Frazier. We would like to reserve 3 minutes for rebuttal.
3 minutes, all right.
Thank you. The matter before the court this morning, is an appeal of the decision of the Shelby County Chancery Court to uphold the Civil Service Merit Board decision, also known as CSMB. On April 10th, 2024, Mr. David McGriff, he was a Shelby County Deputy Sheriff. He was randomly selected to participate in a random drug screening. The results of his drug screening reflected the presence of a cannabinoid, an illegal drug specifically tested during these random drug tests by appellant and for any other testing. Mr. McGriff was one of 17 persons that were tested that day. He was the only person who failed the drug screening. Now, on July 9th, 2024, appellee David McGriff was terminated from his position for violation of the Shelby County Drug-Free Workplace Policy, disobedience of an order, personal conduct were some of the grounds for his dismissal. Now we turn to 3 items we would like to discuss today. First, we deal with the burden of demonstrating cause. And I quote, "The issue considered by the Civil Service Merit Board is whether there was just cause to terminate an individual's employment." That's Case v. Shelby County Civil Service Merit Board, 98 Southwest 3rd, Tennessee Court of Appeals, 2002. Appellant Shelby County bears the burden of demonstrating cause, just cause, for terminating Mr. McGriff's termination. We are aware. So how did we meet that burden? We presented 2 positive drug screenings. 2. With Mr. McGriff's consent, he was tested. There was a urinalysis test. It came back positive for THC. Because of that positive response, another test was done. The hair follicle testing was done. Once again, THC was present in that sample. The way that the THC was ranked in the hair follicle sample is just a little math for you. If the result was 0.3 or lower, then Mr. McGriff would have passed the examination, the testing. However, he registered at 0.4. Nurse Bernard, who is the owner of Test Anywhere LLC, who was hired by Shelby County to complete these drug testing procedures, stated that 0.4 is a high number. That is what she stated in her testimony. So now Shelby County has 2 separate drug screening tests that verify the presence of THC in Mr. McGriff's body. Just cause did exist for his termination. There was no dispute from any party about how the tests were conducted, that they were in alignment with standard process procedures. No disputes about that. There was no dispute either that Mr. McGriff failed 2 drug screenings. Yet, the Civil Service Merit Board failed to include findings of fact. They failed to explain to appellant the reasons for reversing Mr. McGriff's termination, even though he was in violation of the drug-free workplace policy. That is a terminable offense.
Did you, or not you, did the county request the board to explain its reasoning?
We did not ask the board to explain its ruling, Your Honor. They issued a letter of its decision approximately 5 to 7 days after the actual hearing on the 7th. It was 7 days later. We did not ask them to explain their reasoning.
Okay.
So now that we have just cause, the appellant Shelby County, we go to another step, and that is, well, first let me read from the Chancery Court's order when we did ask for a judicial review of the CSMB decision. Quote, well, the Chancery Court order said that there was not, and now quote, sufficient proof to establish that there were other violations that would lead to termination, end quote. This was on the judicial hearing transcript on June 4th, 2025. But, Your Honors, we disagree. We felt that there was nothing else that appellant had to do to justify just cause. Why? We had presented in the CSMB hearing various policies from Shelby County Sheriff's Office where Mr. McGriff was assigned. There were 18 exhibits, 1 deposition, 6 witness testimonies. The CSMB hearing itself, I believe, lasted about 6 hours, 4 to 5 hours. So we made it clear their termination was an available discipline for violation of the appellant's compliance with the drug-free workplace policy. Once the appellant was able to produce evidence to support just cause for termination, Mr. McGriff had to now prove his defense. In our reply brief, we quoted Pruitt v. City of Memphis, and the facts are not exact, but they are similar in that Mr. Pruitt in that particular case faced several charges for termination, and he was terminated. He stated that the city should have refuted his defense, and his defense was that he had a concussion, that he didn't remember certain facts, and this is all after a traffic accident in a city vehicle, that he didn't remember anything. And because that the city did not produce evidence to dispute his evidence, then the city didn't meet his burden. Well, the Pruitt court said that's not how they saw it. He said there's a burden shift. That's what the court said. And I quote, "The onus at that point was on Pruitt to prove his defense," end quote. And that's the same that's true in our particular case.
Why did that not happen here? Yeah, in this situation, as I understand it, the appellee testified that he took some over-the-counter medication that could have provided the results that were obtained.
Yes, Your Honor, that is what he stated. And like Pruitt, the only...
Excuse me just a
Oh, I'm
second.
sorry.
Was that contested?
That he took the CBD gummies, was that contested?
Yes, ma'am.
There was testimony from some of the
No,
witnesses.
that's a yes or no answer. Was that contested?
Yes.
Okay.
Yes.
That he actually did take those?
Was it contested that he actually took the gummies, Your
Yes,
Honor, is
ma'am.
the question? There was testimony elicited that stated we had no idea what he took.
That's not
still not the
that's not my question. My question is, does the county dispute that he testified that he took gummies that could cause that result?
The county did not dispute his testimony, as you stated, that gummies could have caused that result. No, we did not dispute that particular part of his testimony,
Okay,
Your
that's
Honor.
the question I'm trying to get the answer to.
Okay, thank you.
Okay, now, go ahead.
The drug-free workplace policy says it's a violation of the policy to use or be under the influence of illegal drugs here. I'm assuming the county's position is that the policy was violated in the sense that the officer was under the influence of illegal drugs. Is that correct?
Yes, Your Honor, that is exactly our position.
And so what law do we look to then on the illegality aspect of it? Is this a matter of federal law or Tennessee law that THC in the system is an illegal drug?
Is that in reference to the gummy itself?
Well, it's a component of your policy is illegal drugs.
Yes.
So I'm looking for illegality here. There's got to be some law that establishes the illegality of THC of some amount as being a violation of the law. So what law do I look to for that? Is that a federal law, a state law? And can you tell me, cite to the law?
I cannot cite exactly to the law, Your Honor, but I will state we did look to our expert testing anywhere LLC that had that threshold amount of 0.3 and under would have been, there would not have been a positive drug test results, but because he was at 0.4, that is a threshold.
Well, I understand the threshold requirement for the drug testing and whether or not that's sufficient to indicate it's positive, but, and again, my concern is a component of your policy is the drug must be illegal. And as I understand, part of the defense here is that I was taking something that was legal, CBD gummies. What law do I look to for the illegality here? Is it federal or state? Can you tell me that?
I would say in this particular instance, Your Honor, I guess we're looking at state law more closely than any other thing. We're looking at state law.
But following up on Judge McBrair's question, I assume it's not the county's position that that the appellee here bought those gummies illegally. If he said he bought them legally, are you contesting that?
Well, what we are really contesting.
No, go with my question.
Okay.
Are you contesting that he legally bought these gummies?
Yes.
And what proof can we look to in the record to support that?
Your Honor, if I'm understanding your question correctly.
You're the one who answered the question.
Yes. We are contesting that he bought them legally, Your Honor, because we are contesting that he bought them at all. There was no proof put forward. Okay?
He testified, did he not?
He did testify, yes, Your Honor.
And did not the board have the right to believe him or not believe him?
Yes, Your Honor, I agree with that, yes.
Now, obviously, the board did not make a credibility finding explicitly, but by its ruling, it appears they explicitly made a credibility finding, did they not?
I could agree with that, yes, Your Honor, that they made a credibility decision, yes.
Okay. And if the evidence is the county says he took illegal drugs and can't prove where or when he took those drugs, and he says, I bought legal drugs and this caused this result, wasn't the board forced to choose one belief or the other?
I agree that the board had to choose one belief of the other, Your Honor, and I am almost out of time.
Well, that's okay. You can answer my question.
I believe that they had a choice to believe one choice of the other, yes, Your Honor. But whatever their thinking was, is part of our, why we also appeal this case, is their findings of fact lead us to nothing. We have no idea how they reached that decision.
Nor do I.
Okay.
Thank you.
Thank you.
Good morning, Your Honors.
Good morning.
May it please the Court. Bryce Ashby for the appellee, David McGriff. Your Honor, we're asking the Court to deny this appeal and affirm the Chancery Court's decision upholding the Civil Service Merit Board's overturning of the county's decision to terminate David McGriff's employment. The question before the Court is whether the decision by the Civil Service Merit Board was arbitrary and capricious, or whether it was unsupported by substantial and significant evidence.
Is that the question?
I believe it is, Your Honor. That's the only basis for appeal as far as I know.
Well, isn't the first question, can the Chancery Court or this court, looking at the same order that the Chancery Court did, determine why the board did what the board did based upon the record we have before us?
Your Honor, and I believe that the court, Chancery Court and this court can. There's no doubt about the fact that the final decision that was written was wanting for some explanation. But in this court's decision,
that's a very kind description.
I'll do my best, Your Honor, to be diplomatic. But this court in the Macon matter, which I believe Your Honor sat on the panel for, stated that even the absence of an order itself, even the absence of findings of fact and conclusions of law, doesn't mean that a Civil Service Merit Board decision should be overturned. What the court says is that a reviewing court must have sufficient information regarding the agency's action to determine whether the action comports with the law and to avoid substituting its own judgment for that of the administrative tribunal.
Isn't this more problematic, though? Because, and I'd say that in this respect, you've got two differing two vastly differing explanations of how these test results came into being.
We do, Your Honor, and, but as the court...
And isn't it a credibility determination?
It is, Your Honor, but we know the credibility determination because if you look at the deliberations, the transcripts of the deliberations of the board, they clearly lay out how they interpreted that. Specifically, on page 9 through 10 of the deliberations, when they were addressing this, they state that they go through the elements that would have to be proved to show a violation of Section 325, and they recognize that there's no other evidence other than the fact that Deputy McGriff testified that he had taken CBD gummies. Detective Darrell Taylor, who was the investigator of the charges against Deputy McGriff, specifically testified that there was no evidence that he had ingested marijuana. There was no evidence that he had inhaled marijuana other than the positive THC test. And that can be explained based on Deputy McGriff's admission that he had taken CBD gummies. Dr. Sherry Flax, who was a board-certified pathologist, former lab director at Cleveland Clinic, as well as Regional 1, testified that taking CBD products, ingesting them, legally sold, legally purchased, legally consumed, can result in a positive THC test, and that positive test, it's impossible to tell whether that came from illegally purchased marijuana or whether it came from legally purchased and consumed CBD products.
Well, don't we distinguish, though, between legal and illegal by the amount of THC up to 0.3, that's hemp or completely legal? Once you reach that amount, it's illegal. It becomes
That's
marijuana.
correct, Your Honor. That's correct, Your Honor.
And your client tested above that level.
Your Honor, those are different numbers. That's like saying a beer that's 4.5% alcohol. When they test the bloodstream, it doesn't show up at 4.5% in the bloodstream. They're different calculations. So the 0.4 that he tested positive for isn't because there was 0.4% of THC.
So given that, as part of your position here is that the county just didn't make their case before the board initially by connecting the dots behind how the level in the urine and the hair follicle connected up with an illegal level of THC.
That's correct, Your Honor. And if you look at Dr. Flax's testimony, she specifically testifies that taking legally purchased CBD gummies over time could result in a test result equivalent to what Deputy McGriff tested positive for.
Even at that 0.4 level?
Correct.
Okay.
Correct, Your Honor. And so I think, to answer Judge Stafford's, to jump back, the question of whether we met that threshold, we have to look at the record as a whole. And when you look at the transcript, they did a much clearer job of going point by point through all of the charges against my client and answering each one specifically. And, you know, as to this one, they
Here's my problem with that analysis.
Yes, Your Honor.
The board didn't simply say, no proof here. The board said, well, you didn't prove termination, or we're not going to terminate him. We're going to impose some different sanctions here.
Yes, Your Honor.
So I don't know how to interpret that.
Your Honor, they looked at each one of the claims against my client, and 3 of them they said there was not a violation. They said there was a violation for the 4th because just by the fact that there was a positive drug test, they said he's been an officer for 25 years, he's been around this stuff, he just should have known better. Frankly, I think when you look at the elements of that narcotics policy, I don't think there's a violation, but my client didn't want to appeal. He was happy just to get back to work, and he was willing to accept the fact that he should have known better. He testified that. He was a lapse in judgment. He was dumb for doing it, and he admitted it. And his desire was to get back to work. But the county ordinance...
Let me stop you there for a moment, though.
Yes, sir.
What you're talking about is their deliberations.
Yes, Your Honor.
Their conversations among themselves, I take it. I'm looking primarily at the order. And can we consider their conversations between themselves when we're looking at this, if that's not incorporated into the order itself?
I believe we can, Your Honor, because in Macon, they said that you take a look at the order as well as the record as a whole. This isn't,
That's what you do in any case, but it doesn't mean you base your decision on that.
sure, Your Honor, but because of home rule, the county itself is not subject to the TWAPA requirements of having all of these elements that the TWAPA lays out to be in a final order. And the only question is whether the record as a whole, that the reviewing court can look at this and say, we understand how they got to where they are, and it's not an abuse of discretion, there's substantial evidence. And in here, there's really no dispute by the fact that the only evidence in the record is that he tested positive for THC, that he testified that it was a result of CBD gummies, and that there's no evidence that he had ingested or inhaled marijuana, which was the only other illegal drug that could cause this positive test. Those are uncontested facts. And even going to the testimony of sort of the primary decision maker here, which was the Assistant Chief Deputy Laverne, she testified that if this is true, that if he had legally purchased these CBD gummies and taken those, and those resulted in the THC positive test, that there would not be an illegality, there would not be a violation there as a result. And that's where we are. The county can fix this policy really simply. They could say any positive test for THC, because we can't differentiate, that's a violation of the drug policy, and you can be terminated. But that's not what their policy says. What they say is the unlawful use of an illegal drug. And here, they just simply can't meet that burden. The board itself is charged by ordinance with, after holding a hearing, to affirm, modify, or revoke the order of discipline. The county ordinance gives the board, the Civil Service Merit Board, the authority to modify a decision if they think that there are other factors. Here, there was no illegal use of drugs, or they failed to meet their burden in it. They can modify that decision of termination. And that's consistent with, even when you look at the framework for the penalties that are, even if they had found there was a violation of this policy, Exhibit 1 to the hearing record, it shows the penalties that come with each violation, and this one is oral reprimand to termination. So it's the whole gamut that they can choose from. Now, they testified that if there's ever a violation, termination is what happens, and that may be the case. But here, the board found there was not a violation because there was not an illegal drug.
So in the laundry list of available discipline
Yes, sir.
that can be imposed here, how does this discipline that the board proposed actually fit into that process? I mean, because they seem to be concerned about the back pay issue. They didn't seem to think that termination was inappropriate based on the positive test. But how does that fit into the laundry list of potential disciplines that can be imposed?
It's equivalent to a suspension, Your Honor, which is, from his termination, actually before then, from April 10th until the board made its decision, he was unpaid on suspension, and they determined that there would be no back pay as a penalty.
So even though they didn't really use that word, that's the way we should interpret this. So in terms of the duration, I mean, that's the other problem with this order. We don't have any idea, I'm talking about the board's order here. We don't have any sense of how long the suspension should be. We're left to guess to that, aren't we not?
No, Your Honor, they say that he's supposed to be returned December 15th, 2024.
Well, I mean, that was something that does not appear in the order, does it? I mean,
it is not in the order, Your Honor, but it is in the deliberations where they specifically choose that date.
again, we're getting back to the issue about the sufficiency of the order here. I mean, I am also concerned with the notion that a Chancery Court can just listen to the deliberation and say, okay, well, didn't make its way in the order, but I'm going to disregard that and say, and treat it as if it was in the order.
Your Honor, I think that there might be some cases where you would run into overreach if they were picking and choosing, things like that. But if you really look through this order, they go through point by point why they make their decision, and the result of those. And so, again, there's no doubt about the fact that the final decision was poorly drafted, should have been better, and would be helpful for all of us. I would love to have that.
I mean, for all we know, they could have made a conscious decision not to select the December 15th date. That's why they did not put it in their written ruling.
I don't believe so, Your Honor. I really think that at that point, all it is getting that oral discussion down on paper. Now, my understanding of what happened here is that the individual who was assigned to sort of serve that ministerial function of getting it down on paper left after this hearing, so they had to get somebody new, which is why there was such a big gap between November 7th and when we finally got the order on January 13th. But you know, it's crystal clear when they say, when do you want to return the person? And they say, we should look at the pay schedule. They get paid on the 15th or the 31st. When do you want to do it? And they say middle of December, which is December 15th.
Suppose we say here that the ruling is just not the Chancery Court ruling, the board's ruling, it's just not sufficient here. Is the proper disposition to remand it to the Chancery Court to remand then to the board for a more detailed order?
I think that would be the only, it wouldn't be overturning anything, it would just be remanding it for a more complete order, laying out the findings of fact and conclusions.
If that's the approach that this court should take, then is there any difficulty because the passage of time here? I mean, were we going to get the same board members?
It's a great question, Your Honor, and I don't know the status of those board members. I wouldn't be able to tell you that. I think you're going to run into some issues.
Perhaps that's a problem for the county to.
It may be a problem for the county.
Or a question for the county to address.
Yes, Your Honor, and it may be a question of they're just working from the transcript and putting that on paper, at which point it seems unnecessary to take that step when we have a really clear idea. When you really go through this transcript, they laid out point by point, this is where we're going, this is what we want to see happen. Your Honor, as to the back pay issue, even if there were a doubt as to when if he should have been returned the 15th, December 15th or not, when the order came out on January 13th, it was clear that he should have been returned to work. He wasn't returned to work until June 16th. That's a long time in between. And while the board didn't order back pay, they did order him returned to work at the latest January 13th. And so my client was stuck waiting to get back to work without compensation for what turned out to be over a year, which was not what, based on the deliberations of the board, what they intended to happen in this situation. Thank you, Your Honor.
You didn't ask for relief, though, did you?
What's that,
On
Your Honor?
that issue?
I did, Your Honor, with Chancery Court, and the court granted that relief.
Okay, that issue's not, has that issue been appealed?
We have not appealed it because they ordered they be returned on on December 15th.
Okay.
Thank you, Your
Honor. To respond to the back pay issue, we'll start with that first. Yes, we did appeal it. The county did appeal that back pay number from Chancery Court. And I just want to say the word ordered is for the county, we think that's the wrong word. It was not ordered. It was a discussion that was held in deliberations. And let's be clear, please. At the time of deliberations, neither party was in the room. Neither one of us heard what they said. We did not know until about 4 months later what was when we saw the transcript. That was in March, and the hearing was held in November. That's when we learned of a so-called return to work date. It was not in the order, and it was not in the original letter after the decision either. Essentially, they're asking us to give, and I say that purposely, give him over $40,000 from the December date that we were not aware of, when originally they did not order him any back pay at all. There was a process to bring back a public safety officer to his job. It's not as simple as come back to work. There was no discussion with the county, Shelby County Sheriff's Office about what would be a reasonable time. So the Civil Service Board chose, if they chose a date, it was not in discussion with anyone else. And all good faith efforts have been made to bring Mr. McGriff back to work. Now, and if we go by a deliberation transcript in order to determine what the CSMB decision was, then we are also creating something that's not what I think they intended. And that means every time there's a CSMB hearing, are we going to be obligated to get the deliberations transcript to determine what they really want us to do? Because if we can't rely on the order, the complete order, then that puts not only the county, but the employee in a very hard position, because this four corners of the document, you're saying it's not enough.
Are their deliberations supposed to be part of the record?
I believe they can be part of the record, Your Honor, but they're not. The policy that we have in place right now, unless you appeal the order, the decision of the CSMB, then that is how you get the transcripts. They're not provided separately.
And Counsel, I want to pose the same question to you that I posed to Mr. McGriff's attorney. If we decide that we need a better order from the board, or needed a better order from the board to determine exactly what they were trying to do here, I mean, can we remand to the Chancery Court? Well, I know we can do that, but is that a possible way of addressing this? Are we going to get the same board members, or are we going to have problems because the board has changed?
My time is almost up. May I answer your question? Thank you, Your Honor. The same board members are still in place. We just made sure of that before I came up here. They are still in place at this time. And I think we originally...
Let me go back to the question I asked you. So
Yes.
the deliberations are supposed to be part of the record?
You know, Your Honor, I have pulled several cases on that, and it seems that the deliberations can be part of the record. And there was a sister case that I just looked at in Knoxville, and they did speak more about that, about the, what is part of the record. They did speak of it. But what the part that I don't know in that particular case was, were deliberations held in the open as they are now, or were deliberations held as they do privately? All parties are gone. And so you have no notice. You have no notice of what's going on in the deliberations, contrary to how we're doing usually in court or how we do elsewhere. We're not a participant. We're on the outside looking in.
Okay, thank you.
Thank you, Your Honor.
Thank you, counsel.
Thank you all very much, and thank you all for a spirited first time in front of you in the appellate court.